Thanks. Questions and an average. Okay, and if you try to look at the questions, the number of questions in 2022 and 2023. So in 2022, 10 questions. In 2026, 16 questions. Okay, but of course, it is maintaining the same average across the years. Okay, but what is the difference? The questions are getting complicated year after the year. Okay, questions are getting complicated. So what does it mean by getting complicated? Okay, generally we people study only constitution. Okay, the examiner is not interested to frame the questions only on constitution. Rather, he is adding what? Law. So it means you require to study not the constitution itself. Rather, you need to study law, constitutional law. The present trend is constitutional law. Everybody accept with this statement? The very evidence is in the 2023 examination, there was a question asked. Okay, the question that was asked was, in an essence, what does due process of law mean? What does due process of law means? Okay, tell me, where can you find the due process of law? Under which article of the Constitution? Under which article of the Constitution you come across the term due process of law? Whether is it mentioned in the Constitution actually? I am asking you a straight question. Whether is it mentioned in the Constitution? It is not mentioned. It is not mentioned. It means the UPSC is supposed to ask the questions from the Constitution. Rather, it is asking the questions from the interpretation. It is asking the questions from interpretation. Who interprets the Constitution? Supreme Court and High Courts. Supreme Court and High Courts. But generally, Supreme Court judgments will be applicable all throughout the India. Hence, usually we take the judgments of the Supreme Court as a standard. Because under Article 129 of the Constitution, the judgments of the Supreme Court are considered to be court of record. What is that? Court of record. Did you understand? So hence, we need to go deep into the matters. Okay, now tell me, in this context, what would you understand the meaning of due process of law? Can anybody simply give me a definition, a simple definition? What amounts to due process of law? Anybody, please? Anyone? You have studied, right? Article 21, if you study that, immediately you can easily understand. The very context of this question is the judicial activism. What is that? Judicial activism. What is the judicial activism? Proactive and positive interpretation of law by the Supreme Court is called as judicial activism. The very purpose of the judicial pronouncement by the Supreme Court is to ensure the justice, Whether it is laid down in the law or not laid down in the law, it is immaterial to the Supreme Court. That's why the Supreme Court exercises the power under Article, what is this? 142 of the Constitution. What does 142 of the Constitution talk about? The power of the Supreme Court to grant complete justice. The power of the Supreme Court to grant complete justice. Did you get my point? Complete justice means whenever anything is not clearly laid down in the Constitution, whenever it is not properly mentioned in the statute, in that occasion, Supreme Court will be playing a gap-filling role. That is the essence of Article 142 of the Constitution. Article 131 of the Constitution, Article 132 of the Constitution, Supreme Court is the highest court of the land to interpret the Constitution. In that capacity, it interprets the law. It interprets the law. You may ask me, sir, why are you quoting the articles frequently? UPSC is interested to know your knowledge about articles also. UPSC is interested to know the knowledge about articles also from your side. So hence, please be aware of this fact. Okay, right. Then, see, they are asking the questions right from the judgment itself. That's why, right from the judgment itself. So what is the context? What is the context? What is Article 21? Tell me. So I am trying to train your minds. This is the very purpose of this class, to teach you polity or give you the entire details of the prelims. Okay, but what I am purposeful, for what reason I am here? To train your minds. How to orient your preparation strategy. In what sense you need to approach the subject. That is what my concept. Okay, right. So Article 21 of the Constitution talks about what? Yeah, please, you should study the original Constitution, not Lakshmikant. You can study Lakshmikant, but you need to understand the clear provision in the Constitution. Okay. What is this article? No persons, life and liberty cannot be deprived except according to, tell me what? Procedure established by law. This is what the article talks about. No person means any individual, whether he is citizen or alien. Okay, for everybody this right actually applicable. Life and liberty. Life has been interpreted by the Supreme Court in most of the instances. For example, Supreme Court has interpreted the life as privacy. What is that? Privacy. The Supreme Court interpreted life as right to have a respectable death in the form of euthanasia. In Aruna Shanbag versus Union of India case. Supreme Court has interpreted liberty also in various instances. Life and liberty also covers privacy also. That's why Supreme Court has interpreted this particular term in most of the instances. Life and liberty also covers right to marriage, right to shelter, right to livelihood. In this way, Supreme Court has interpreted most of the instances, life and liberty. Okay, right. And what else it says? Yes, life and liberty of a person cannot be deprived except according to the procedure established by law. So it means the very statement explains that in India, the Constitution imposes the reasonable restrictions on the fundamental rights. What is the reasonable restriction here? Procedure established by law. You can't have any absolute right. Your rights are having reasonable restrictions. Reasonable means, what is the meaning of reasonable? Wherever there is a need, wherever there is a necessity, there will be restriction. There will not be any unnecessary restriction. Okay. So, this particular due process of law has been recognized officially by the Supreme Court in the Menaka Gandhi versus Union of India case of 1978. Got my point? Generally, before the Menaka Gandhi case, what was the perception, the popular perception? Even judicial perception is also same. Even in the A.K. Gopalan versus State of Madras, what was the perception of judiciary is, if the parliament lays down the law and the executive acts according to the law, okay, it is legal on part of the executive to take away life and liberty. If the law is saying that, yes, the officer can take away the liberty of the individual and the officer also takes away the liberty of the individual, then it is valid according to Article 21. So it means the judicial scrutiny is not possible whether such executive power is used for the reasonable purpose or unreasonable purpose. Are you able to understand? Suppose if the executive tries to hamper or violate the rights of a single individual, okay, particularly an individual with a kind of a revenge or with a kind of a retribution, the judiciary cannot stop the executive action. Did you get my point? In this context, you need to know the difference between legality versus arbitrariness. Legality versus arbitrariness. What is legality? What is arbitrariness? Can you understand this term? What is legality? What is arbitrariness? Legality means what? If you are confining, if you are complying with the law of the land, that is called as legality. But when you use the power conferred by the law according to your personal choices and whims and fancies, that is called as arbitrariness. Arbitrariness. Suppose I have the power to make any student to go out of the class, for example. Okay. If I am using this power, that is called as legal. Okay. If I am selectively using this rule against any individual in the class, is called as arbitrariness. That is arbitrariness. It means till 1978, the judiciary permitted the judicial review only particularly to legality. It was not concerned about what is that? Arbitrariness. It was not concerned about arbitrariness. Got my point? For example, Maneka Gandhi wanted to travel abroad. Okay. And the passport officer impounds her passport according to Indian Passports Act of 1967. Section 10 of the Indian Passports Act empowers the officer to take away the passport of the Maneka Gandhi. Okay. But unfortunately, this section 10 does not clearly give what are the procedural methods, what is the procedure, okay, that is to be followed in the process of depriving the liberty of an individual. That was not specified under section 10. That was not specified under the section 10. Then what happens? Maneka Gandhi approaches the Supreme Court. Maneka Gandhi approaches the Supreme Court and she files a petition. Sir, Article 19 Class 1 Subclass G talks about right to profession, right to business and right to occupation. Okay. Right. Article 21 talks about right to life and liberty. Right to life and liberty. Article 14 talks about equality before law. Equality before law. These three articles are very much clear in the Constitution. She says, the law is arbitrarily employed against me because the law does not clearly detail the procedure how the officer has to take my passport into custody. And this particular method is applicable against me in a biased manner. They are selectively identifying me and applying this law. This is arbitrary. This was her argument in the Supreme Court. Then Supreme Court used the extraordinary power under the, what is that? Due process of law. Actually, in the Constituent Assembly, there was a discussion whether Article 21 shall be franked with the procedure established by law or due process of law. Then Ambedkar answered to that particular discussion stating that, sir, at this point of time, we require only procedure established by law but not due process of law. Why not due process of law? Because this due process of law may have the ability to give unlimited powers to the judiciary to interpret the law according to its wishes. Are you able to understand? Actually, this power is given with the American Supreme Court. This power is not vested with the Indian Supreme Court. Indian Supreme Court has shown the restraint till 1978. But the moment the level of arbitrariness has increased, the judiciary started using the power vested with the due process of law. It means due process of law is court-defined power. It is the court-defined power but not constitutionally defined power. Did you get my point? Then, what was the judgment of Supreme Court, you know? The Supreme Court says, since section 10 of the Indian Passport Act does not give the procedure, it cannot give unlimited power to the officer to take away the passport. If the passport is to be taken from the individual, the officer has to follow a process called as principles of natural justice. What is that? Principles of natural justice. You need to follow principles of natural justice. What are principles of natural justice? Can anybody tell me what is the meaning of the principles of natural justice? Any principle to be followed by any authority, if it is correct according to the moral framework of the individual, that is called as principles of natural justice. Got my point? If it is according to the moral framework of the individual, that is called as principles of natural justice. Simply you understand, if I ask any student to go out of the class, if I don't tell any reason, is it correct according to the viewpoint of other students? Whether other students would support my decision? No, because everybody may demand the reason why such student has been evicted from the class. Got my point? So it means that becomes only correct when I am able to give the reason. Not only that, not only giving the reasons, the person must be able to respond to my question. She must be able to give her own version or give his own version. Are you able to understand? So it means I cannot impose a punishment till she or he gives her own version of violation. Got my point? So then in this way, it constitutes the principles of natural justice. So usually the principles of natural justice composed of generally three important principles. That is, no man is the judge of his own case. Okay, what is the next principle? No man shall be condemned. What is that? Unheard. No man shall be condemned unheard. Next, third one is absence of bias. Absence of bias. Okay. And there is another important principle, that is that justice must not only be done, it must also be appears to be done. Justice must also be appears to be done. In this way, there are 4 principles to be followed in this procedure. So tell me whether any such principle has been followed in the case of Maneka Gandhi case? No, because she was not given any reasonable opportunity to prove her innocence, or to give her own version. So if you don't follow these principles, that is called as, what is that? Arbitrariness. Then Supreme Court has held that when the case can be just, fair and reasonable, it means the executive not only required to follow the land, okay, follow the law of the land, but also he has to exercise the law in just, fair and reasonable manner. The application of law must be just, fair and reasonable manner. When the application of law can be just, fair and reasonable, when you are following the, what is that? Principles of natural justice. That makes the action of any executive just, fair and reasonable. So next, what could be the right answer? What is that? Fair application of law. What is the procedure you have adopted? Principles of natural justice. In this way, judiciary not only scrutinizes the constitutionality of the legislation, it also finds out the purpose of the law. Tell me, now you answer me, who is empowered with the power to find out the purpose of the law according to the constitution? Is it judiciary? No. Who is that? Legislature. What is that? Legislature. Because legislature is a house which is a lawmaker. Okay. And legislature is also representatives of people. It is also representative of people. If any question of such a purpose to identify the purpose of the law or the meaning of the law or the requirement of the law, who is the right agency? Legislature. But in the name of due process of law, who is getting into those shoes? Judiciary. In other words, because of this power, the Supreme Court is emerging like a, what is that? Super legislature. What is that? Super legislature. It means it is completely deviating from the written text of the law. It is getting into the domain of the legislature. Got my point? If you don't understand the Maneka Gandhi case, you will not be able to understand the essence of this question. Tell me, does it justify my interpretation of the examination? What is becoming true? Reality? Constitutional law. Constitutional law is the reality. Got my point? You need to understand every judicial verdict in the recent times to identify the right answer in the prelims. Okay? Right. So, and moreover, the questions are becoming more conceptual in nature. Of course, there is a diversity of questions are being asked. But questions are also conceptual, which will test your core understanding of polity, core understanding of the constitutional principles. Okay, for example, you just look at this question. What is this question? Tell me. Consider the following statements. A constitutional government is the one which, okay, it was a question asked in 2014. Okay, what is the question, you know? What is the meaning of constitutional government? What is the meaning of constitutional government? Right? Can anybody please tell me what is a constitutional government? In your understanding, what is the meaning of constitutional government? What is a constitutional government? Can you define what is constitution? Can you define it? Yes, constitution ante enti? Just everyone cheppandi random ga, idem mee test of knowledge kaadu. Cheppandi, what is constitution? Yes, supreme law of the land. And what else? I think most of you have attended my classes, isn't it? Is it true or false? Yes. I began with the same definition. What is that? Constitution is a document which explains the formation of the state and also explains the relationship between the people and state. Okay. What is the relationship between the people and state? What is the relation? The relation is simply, it defines what are the do's on part of the government and what is that? Don'ts on part of the government. Constitution defines what is that? Do's on part of the government and don'ts on part of the government. When you are clearly specifying what are the do's and don'ts, then what is the government? What is that? What is that? Places effective restrictions on the authority of the state in the interest of the individual liberty. Got my point? I discussed with you the concept of social contract, where there will be a contract between the state and the individual. And individual will be submitting his some of his rights. And what is expected? The state will be providing the protection to the rest of his rights. So in other words, the state is prohibited from entering into the zone of the individual's fundamental rights. So it means, are you not imposing the restrictions on the authority of the state? Yes. Such imposition is seen in the form of, what is that? What is that? Fundamental rights. Got my point? You are giving the fundamental rights to the people. Okay? Actually, you are not giving. The people are declaring their rights in the form of part 3 of the Constitution. So these fundamental rights will help the individual to get protected from the, what is that, despotism of the state or domination of the state. Despotism or domination. If the state behaves in any unreasonable manner, the individual can question such action and he can also approach the Supreme Court directly under Article 32 of the Constitution. In that way, the fundamental rights are given highest significance in the scheme of Constitution. Okay, when you are giving highest significance to the in the scheme of the Constitution, what does it mean? You are imposing the restrictions on the authority of the state. And if I ask you, what is the nature of the fundamental rights? Are they positive rights or negative rights? Can anybody raise the hands who are saying positive or negative? Who are saying negative? Tell me. Please. Who are saying positive? Everybody has to participate, please. Who are saying positive? Please. Who are saying negative? I am not able to get the clear picture anyway. Okay. Negative right means what? Positive right means what? Negative right means it is the right which is given to the individual which prohibits the intervention of the state into the lives of the individual. Okay. It clearly gives out a zone which is prohibited for the state to enter. That is called as negative right. Any right which imposes a responsibility on the shoulder of the state, that is called as positive right. So tell me, fundamental rights are negative or positive? Negative in nature. Because they clearly prohibit the state intervention into the rights of the people. Rights of the people. Why the state cannot violate the rights? Tell me whether the fundamental rights are the gifts given by the state. Yes or no? These are not gifts. These are nothing but self-declaration of the people. It is not my opinion. It is opinion of the Supreme Court in Nagaraj versus Union of India case. In which case? Nagaraj versus Union of India case, Supreme Court itself held the fundamental rights are declaration by the people. Declaration by the people. Part 3 is not the gift given by the state. It is simply declaration. But when you are declaring the rights, sometimes you may not be able to discover the new forms of rights. Then who will be discovering new forms of right? Judiciary. By means of the judicial interpretations, it keeps on expanding the rights available to the people. That's why Article 21 has been interpreted as right to environment, right to privacy, right to dignity, right to livelihood, right to marriage, right to sleep, right to medical assistance, right against right against torture in the jails. In this way, in various interpretations, we can find it from the judiciary. Got my point? That's why fundamental rights are negative in nature. Okay, DPSP are positive in nature. But there are certain few fundamental rights which are positive in nature, which include Article 15 Class 3, special provisions for women and children. It means the state has the responsibility to create the conducive environment for the certain vulnerable sections. State has a responsibility. When you say state has a responsibility, that becomes positive. State has a prohibition, that it becomes negative. For example, Article 17. What is this? Is abolition of untouchability. State is not supposed to state is supposed to create the conducive atmosphere for the SCs in the country by abolishing the untouchability. Article 18, abolition of titles. Article 23 and 24, prohibition of, what is that? Prevention of exploitation of labor, prohibition of child labor. All these become, what is that? Positive rights. Got my point? In this sense, most of the fundamental rights are negative or positive? Negative in nature. Very few fundamental rights are positive in nature. That's why Constitution places effective restrictions on the authority of the state. But first statement is incorrect. Why? It places effective restrictions on individual liberty. Is it so? Effective restrictions? No. Reasonable restrictions. What is that? Reasonable restrictions, not effective restrictions. So hence you can outrightly reject the first statement. Then what is the right answer? 2 only. Got my point? So that's why you need to understand the concept behind the questions. When you understand the concept, it is so easy to find out the answer. Okay? Right. Right. Now with the same understanding, please answer this question. Because I told you, you must understand one more important thing. Questions are asked repeatedly on the same concept, time and again. Concept is same, but the form of the questions are variation. That's why when you study the previous year's question papers properly, you can easily identify the theme of the UPSC examination. Okay? The same thread is running across all the years. Okay? Look at this question. A constitutional government by definition is, what is the type of government? Tell me now. Yes, very good. It is the limited government. This is a question asked in 2021. Okay? Whereas the previous question was asked in 2023. This question is asked in the 2014. See the nature of the questions. Same question is being found repetitiously in various forms, but the concept is same. Okay? Right. Supreme Court judgments are being asked this way. Look at this question. Under which of the following articles of the Constitution of India safeguards one right to marry the person of his own choice? Which article? Article 21. Supreme Court has given this verdict in 2 cases, Lata Singh versus State of Uttar Pradesh and also Hadia case. What is that? Hadia. Okay. In these 2 cases, Supreme Court has given this verdict under Article 21 of the Constitution. The Supreme Court has expanded the term liberty and life in various dimensions, in various judgments. Okay? Right. Next. Right. Now look at this question. Which one of the following reflects the most appropriate relationship between the law and the liberty? Okay. And another trick that is being followed by the UPSC is, it will be giving most of the answers in the very much closely related. The options will be given only which are very much closely related, and you have to identify the relatively better answer. Relatively better answer. So there is a chance of subjectivity from the examiner. Subjectivity means what? He is imposing his own views on us. Okay? Right. So look at the first statement. If there are more laws, there is less liberty. If there are more laws, there is less liberty. Is it true or false? Okay? True or false? More laws, less liberty. Can you really identify if number of laws are increasing, the liberty will be decreasing? Actually, no. Actually, if you try to look at what is the term liberty? Liberty means what? It is the freedom of individual. What is the difference between freedom and liberty? Got my point? What is the difference between freedom and liberty? What is freedom and what is liberty? Freedom means complete absence of restraints on the individual. That is called as freedom. What is liberty? If there are reasonable restrictions on the individual, that is called as liberty. For the country like India, which is most suitable thing, liberty or freedom? Liberty. Okay. You might have studied in the case of American Constitution, the rights given under the American Constitution are absolute in nature. What is that? Absolute in nature. What is the meaning of absolute? Can you differentiate the term absolute and qualified? Qualified means what? What is absolute? Are you able to understand my question? Can you differentiate what is the meaning of the term qualified versus absolute? Qualified means if there are reasonable restrictions, that is called as qualified. Absolute means there is a complete absence of restrictions. Complete absence of restrictions is called as absolute. American Constitution has not provided any kind of restrictions within the Constitution. But tell me whether America presently, the citizens of America are having any restrictions on their fundamental rights? Yes or no? Yes. How is it possible? It is possible because of the judicial interpretations. It is possible because of the judicial interpretations. The judiciary constantly expanding the scope of restrictions over the rights of the people of America. Got my point? Why I am saying, because in any country, if the governance has to happen in a smooth manner, people shall not be having freedom, rather they must be having liberty. Because just because you have freedom, you can't spoil the freedom of others. You can't spoil the rights of the others. That's why that is the logic. The rights of an individual cannot be violating the rights of the other individuals. So hence you are providing the reasonable restrictions. Whether in our constitution such reasonable restrictions are provided or not, yes, provided. Can you give me examples, any example for the reasonable restrictions? For example, Article 19 Clause 1 Subclause A. What are the restrictions available under Article 19 Clause 1 Subclause A? In the form of 19 Clause 2. What is 19 Clause 2 talks about? It talks about sovereignty, integrity, okay, friendly relationship, foreign states, security of the state, decency, morality, public order, contempt of the court. Okay, in this way, various restrictions are available, various reasonable restrictions are available in the Constitution. Article 25, right to conscience, right to practice, right to profession, right to propagate the religion. Reasonable restrictions are provided by the state's power to run the secular activities of the religion and going with the social reform. Social reform is also reasonable restriction. Article 23, prevention of exploitation of labor. It also has the reasonable restriction. What is that? 23 Clause 2, which says the conscription. What is that? Conscription cannot be said to be exploitation of labor. What is conscription? Compulsory military service. What is that? Compulsory military service is not exploitation of labor. In this way, reasonable restrictions are there. Got my point? And in this context, liberty has two dimensions. What is that? Positive liberty and what is that? Negative liberty. Liberty has two terms. What is that? Positive liberty and negative liberty. What is positive liberty? What is negative liberty? Negative liberty means what? I told you just now, that is the zone of prohibition for the state, where the state cannot interfere with the rights of the individuals. Okay, that is called as negative liberty. Whereas positive liberty means, it is a area of action for the state. It is the area of action for the state. Why we are saying it is an area of action for the state? Because state has to provide various laws which can provide opportunities for the people. Which can provide opportunities for the people, which can provide level playing field for the people, which can provide safeguards for the people. Such kind of activity is called as, such kind of liberty is called as positive liberty. In America, which liberty you will be able to see? More amount of negative liberty. But India like countries, the government will be trying to expand, what is that? Positive liberty. Why positive liberty is very much suitable to India? Because India is having many inequalities. In this environment, in this particular socio-economic conditions, you can't leave the people to their fate. You have to enact such progressive laws which can expand the ability and capacity of the individuals. So such expansion is possible only when the state activity is seen in the form of, what is that? More laws. Okay, so that's why more laws may not be proportionate with the or disproportionate with the liberty. Hence, what is this? Wrong statement. Got my point? Did you get my idea? Yes. Next, if there is a liberty, laws have to be made by the people. Is it true? Anyway, laws are being made by the people only. In the form of representative institutions. In the form of representative institutions. Got my point? I told you in most of the classes, what is the meaning of law? I have defined law very precisely. What is law? Tell me. Law means what? I have given two definitions. One is, it is a set of principles which are enforceable in character. That is called as law. Whenever you find any rule, if it is enforceable in nature, that is called as law. And law can also be identified with a democratic meaning. What is the democratic meaning? Law is nothing but expression of the opinion of the people, expression of the will of the people. Who is expressing the will of the people? Legislatures are expressing the will of the people. How come the legislatures can express the will of the people? Because these are elected by the people. So when the legislators are making the laws, it is nothing but they are taking such authority from the people's opinion. That's why laws are nothing but expression of the opinion of the people. So hence this statement is also incorrect, because people need not enact their own laws, because legislature anyway it is doing the same. Okay, right. Next, if the laws are changed too often, liberty is in danger. Is it true? There is no clear relationship, there is no clear correction between the frequent enactment of the laws and the loss of liberty. Frequent enactment of the laws and the loss of liberty. For example, you see SC/ST Atrocities Prevention Act 1989. Okay, it was amended in 2015. It was amended in 2018. So it means a law is undergoing frequent amendments. Why the law needs to be amended frequently? Because when the society is dynamic, the requirement and aspirations of the people is also dynamic. People will be changing their opinion from time to time. Definitely you may require more number of laws, more frequent changes to the laws. Hence, the fourth statement is also incorrect. But here, if there are no laws, there is no liberty. There are no laws, there is no liberty. Are you able to understand? Suppose I am standing here. Okay, I am teaching you class. With what guarantee, with what assurance I am teaching you, no? I am very much assured that I will not be attacked by any other person. In case of any attack, immediately police will come. If I dial 100, the state is guaranteeing my security and safety by means of what? Laws. So it means my liberty is dependent upon the law. If there are no laws, no liberty. So answer is what? B is the answer. Got my point? So that's why you need to work very seriously on the examination. You can't just go to examination hall casually. You need to apply the reason in the form of mock tests. Okay? When you are turning your mind this way, definitely success will be, what is that? A sure shot. Okay? Right. Next. One more important thing. Frequently, very routinely, the question of governor's discretion is coming into the news. Is it so or not? Yes or no? Especially if you try to look at the southern India, especially Tamil Nadu, Kerala, wherever opposition states are being ruled by the opposition state, wherever the states are ruled by opposition parties, there you can see the controversy related to governor. Yesterday or day before yesterday, governor of Tamil Nadu declined to read the statement of the government in the form of governor's address. He was not ready to read out the policy document of the government. Policy document of the government. Is it correct or wrong? Is it correct or wrong? Okay? మీకు అర్థమవుతుందని నేను అడిగిన క్వశ్చన్. Governor is very much hesitant to read out the policy document of the government in the form of governor's address. Is it right or wrong? But Constitution says under Article 163 of the Constitution, it says no. Governor will be aided and advised by the Chief Minister and the Council of Ministers. This is what parliamentary form of democracy, where the real authority is Chief Minister and Council of Ministers and nominal authority is Governor. At the union level, who is the nominal authority? President. And who is the real authority? Prime Minister and Council of Ministers. Okay? But if you try to look at Article 163 of the Constitution, one of the clauses of Article 163 says, that is Article 163 Clause 2 probably, this article says, whenever any matter to be decided by the governor, whether it falls under his discretion or not, whose opinion is final? Governor's opinion is final. Governor's opinion is final. మీకు అర్థమవుతున్న పాయింట్ అంటే one clause of the article 163 says chief minister and council of ministers are to aid and advise the governor. Governor is expected to follow the advice of the chief minister and the council of ministers. But whenever governor gets a doubt that whether this matter is falling under his discretion or not, his opinion is final. His opinion is final. Using this clause, governor is making all this controversy. Using this clause, governor is making all this controversy. You compare this article 163 with article 74 of the constitution. Article 74 of the constitution. What is article 74? Prime minister and council of ministers aid and advise the president. Okay, prime minister and council of ministers aid and advise the president. But in the case of this article, there is no such there is no such provision which talks about the discretion of the president. Which talks about the discretion of the president. But article 163 talks about the discretion of the governor. Discretion of the governor. So that's why in the scheme of the constitution, who is powerful? President is powerful or governor is powerful in their own respective fields. Governor is powerful at the state level. Governor is powerful at the state level. Got my point? Yes, this point is very, very essential to remember to answer this question. Okay, right. What is the question? Which of the following are the discretionary powers given to the governor of a state? Okay, right. So, sending report to the president of India, imposing the presidential rule. Which article talks about this? Article 356. The discretion of the governor is mentioned under article 356 also, where governor can send the report to the president regarding the imposition of the presidential rule. So it means whether the state requires a presidential rule or not, it is not decided by the chief minister and council of ministers. Who is deciding that? Governor himself is deciding. Right. So hence, this is the right thing. Next, appointing the ministers. Is it discretionary power or binding? It is binding on the governor by the advice of the chief minister, because chief minister has a power to advise the ministers of his choice. Governor cannot have any discretionary power. So under article 164 of the constitution. Hence this is wrong. Next, reserving certain bills passed by the state legislature for the consideration of the president of India. Tell me, is it true or false? True. Why it is true? Because article 201 says the governor can reserve certain bills to the presidential consent. Why the presidential consent? Because the state government may be exceeding its powers that are constitutionally given. Suppose state government is amending any law which is mentioned under the concurrent list. What is that? Concurrent list. Do you know what is concurrent list? It is a list where the state government can make the laws and union parliament can also make the laws. Any such law is inviting any discrepancy from the parent law, such kind of bills can be forwarded to the president. If any state bill is endangering the position of the High Court, then also it can be forwarded. Any bill which is against the constitutional spirit, such bills can also be forwarded to the president by the governor for his assent. For example, Article 20 says there shall not be any self-incrimination. No person shall be acting as a witness against himself in any case. Suppose taking the power, the state legislature may be amending any criminal law and which may be giving a provision for the self-incrimination in any given law. Is it in accordance with the constitution or in violation of the constitution? In violation of constitution. Such bills can also be reserved by the governor to the presidential assent. So hence, what is the right answer? This is also right answer. Making the rules to conduct the business of the state government, is it discretionary power? No. Why? Because the governor has to frame the rules according to the advice of the chief minister and the council of ministers. Then what is the right answer? 1 and 3. Got my point? So that's why questions will be very much contextual. So when governor's controversy is very much visible, definitely we need to follow such cases. Okay, right. Next important matter is recently means in 1 or 2 years back, there was a judgment that is called Nabam Rabia judgment. What is that? What is that? Nabam Rabia judgment. What is this Nabam Rabia case? Nabam Rabia. What is that? Nabam Rabia. Do you have any idea about Nabam Rabia judgment? It is very, very important judgment. Why? Because in Uttarakhand, in the state of Uttarakhand, what happened? The opposition parties and certain members of the ruling party wanted to remove the government. So it means there were rebel MLAs within the ruling party. Who are they? Rebel MLAs. This rebel MLAs wanted to support opposition party government. So they wanted to form the government in cooperation with the opposition party. Learning this, immediately speaker, what did the speaker do? The speaker disqualified such members under Anti-Defection Act. Under which act? Anti-Defection Act. He did not disqualify, he actually sent the notices. Why can't I disqualify you? Because you are going against the ruling party. You are going against your own party. Because what is the Anti-Defection Act? Anti-Defection Act of 1985, what does it talk about? It disqualifies any MLA or MP who is switching to the other political party in unethical manner. Such things will be disqualified by the presiding officer. Okay? Right. And in the year 2003, okay, the Anti-Defection Act was amended by the 91st Constitution Amendment Act. By which act? 91st Constitution Amendment Act. What is this 91st Constitution Amendment Act? If 2/3 members are separating from the political party or they are joining any political party, that cannot be considered to be defection. And they will not attract the disqualification. This is how the Anti-Defection Act is there. Then what happened? Speaker immediately, when the speaker sent the notices to the rebel MLAs, immediately what happened? These MLAs they passed a resolution for the removal of the speaker. They have given the notice for the removal of the speaker. Did you understand? Speaker gave the notice under Anti-Defection Act. Members have given notice for removal of the speaker. Now the members claim that when the removal resolution is pending in the Legislative Assembly, you cannot disqualify us. We are questioning your authority because we don't have the trust on you. Got my point? Right. Now tell me how the speaker is removed. Got my point? How the speaker is removed? Tell me, edla remove chestaru? ఏ మెజారిటీతో రిమూవ్ చేస్తారు స్పీకర్ని? స్పెషల్ కాదు. వాట్ ఈస్ దట్? ద దెన్ మెజారిటీ ఆఫ్ ది హౌస్ డిసైడ్స్ ద స్పీకర్స్ రిమూవల్. వాట్ ఈస్ దట్? ద దెన్ మెజారిటీ ఆఫ్ ది హౌస్. ద మెజారిటీ ఆఫ్ ది హౌస్, ద మెజారిటీ ఆఫ్ ది హౌస్ ఆఫ్ ద దెన్ మెంబర్స్. Majority of the house of the then members. Suppose in Telangana Assembly 119 members are there. Suppose 5 members have resigned. How many members are there? 114. So majority is to be tested in 119 members or 114 members? 114 members. This is what called as effective majority. What is that called? Effective majority. Okay. So in this way the speaker has to be removed. Okay. Then the speaker moves to Guwahati High Court. Okay. And in the High Court imposes a stay on the both speaker's disqualification notice and removal notice. Then again the matter reaches to the Supreme Court in front of the 5-judge bench. Under Article 145 of the Constitution, if the bench is having more than 5 judges, is called as Constitution bench. What is that bench? Constitution bench. Constitution bench is the bench which consists of more than 5 or more than 5 members. That is called as Constitution bench. So that bench actually adjudicated this matter. Then what is the verdict of the Supreme Court? It has upheld the opinion of the rebel MLAs. Because whenever the removal resolution in pendency, speaker has no power to disqualify the members under Anti-Defection Act. This is point number 1. Are you able to understand? Yes. Number 2, role of governor here. Actually, government solicited governor, please, summon the legislature. Please summon the legislature. Why to summon the legislature? Because we want to prove our majority. If the time is going on, if the time is extending, what is happening? The opposition party is actually going with the purchase of our MLAs. So please immediately summon the house. But governor did not heed this advice. Governor did not heed this advice. Then what Supreme Court held, governor has no power to delay the sessions of the House. Governor has no power to delay the sessions of the House because the governor has to act upon the advice of Chief Minister and Council of Ministers regarding the summoning of the House and also prorogue of the House. Regarding the summon and prorogue of the House. This is also the outcome of the judgment. The Supreme Court specifically said, governor cannot summon the House, cannot determine the legislative agenda. Governor, without the consultation with the government, cannot address the House. Cannot address the House. 3 points. Governor cannot summon the House without the advice of the Chief Minister and Council of Ministers. He has to act upon the advice of Chief Minister and Council of Ministers. Governor cannot decide the legislative agenda. Enduku legislative assembly enduk meet avutundi? Why this assembly is going to meet? Whether to prove the majority or disprove the majority, whether to remove the government or whether to pass the law, this is not within the domain of the governor because legislature has to set its own agenda. Governor has no agenda to dictate to the legislature. Got my point? Number 2. What is the number 3? Governor cannot address the House without the advice of without consulting the government. So in this case of Tamil Nadu Legislative Assembly, if the governor of Tamil Nadu reads out anything other than the document given by the government, is it constitutional or unconstitutional? Unconstitutional. Governor requires to study read out the paper that is given by the government. Official policy of the government must be read out by the governor, but not the individual policy of the governor. Governor cannot replace the terms in the policy document that is given by the government. So any question comes in this format, the governor can replace certain terms with his own discretion. And ante adi right or wrong? Wrong. Enduku wrong? Because of the which judgment? Nabam Rabia judgment. Which judgment? Nabam Rabia judgment. అర్థమవుతుందా? చూడండి. అంటే you need to be very much aware of the Supreme Court judgments. You need to read the constitution provisions in the light of the Supreme Court judgments. Okay? Right. Okay, now look at this another conceptual question regarding the local self-government which was asked in the year 2015. Okay, are you able to read this? Yes. The fundamental object of Panchayati Raj system is to ensure which among the following: people's participation in the development, political accountability, okay, democratic decentralization, financial mobilization. చెప్పండి, వాట్ ఈస్ ద పర్పస్ ఆఫ్ ది పంచాయత్ రాజ్ ఇన్స్టిట్యూషన్స్? మీ ఒపీనియన్ చెప్పండి. జస్ట్ టెల్ యువర్ ఒపీనియన్. Participatory democracy. The very essence of the Panchayat Raj system is what? Participatory democracy. Because voters of the village or themselves are the members of the Gram Sabha. So it means voters themselves are legislators in other sense. Voters themselves are the legislators. But in the case of parliament, voters are different, parliamentarians are different. But here, I myself is the voter and myself is the representative of myself. I will be asking the question on myself, on behalf of myself. That is what giving the sense of what is that? Participatory democracy. So people will be deciding the developmental agenda of the village. Okay. Hence the people participation in the, what is that? Development. Okay. Next important thing is what? Democratic decentralization. Democratic decentralization. And what else? Political accountability. Political accountability. Okay. But which is more reasonable? Political accountability means it is not giving the clear sense here. Political accountability does not give the clear sense here. So hence this option is ruled out. So what we have to follow? People's participation, democratic decentralization. So then what is the answer? C is the answer. Okay, the essence of the democratic decentralization is not the political accountability. Accountability is one thing is to be followed. But what is more important? You need to ensure the participation of the people in the development and also democratic decentralization. So closely given options need to be understood. Okay, examiner may try to play his own role by giving the subjective statements, but we need to eliminate the unnecessary statements. Here we need to clearly link these concepts of the Panchayat Raj system, because parliamentary form of democracy, this is a common point. Political accountability is a common point. With respect to parliamentary form of democracy also there is political accountability. At the state level also there is political accountability. But what is peculiar with local self-government? The peculiarity is what? People's participation and what is that? Democratic decentralization. Got my point? Yes. Next. See, another closely related question. This is also UPSC question. See how the same question is being asked multiple times. Which of the following purpose of the constitution, okay, best reflects the chief purpose of the constitution of a country? Tell me, what could be the right answer? It determines the objectives for making of the necessary laws. It enables the creation of political offices and a government. It defines the limit of the government, and it secures the social justice, social equality, and social security. What is that? Cheppandi, A is the option. A, B, C or D? C is the option. C is the answer. Got my point? He may divert you with this kind of statements. Whenever social justice is appeared, you will feel that yes, social justice is the answer. That cannot be the right answer. You need to have the core knowledge here. That's why the right answer is it defines the limits of the powers of government. Got my point? Right. Next. Which one of the following factors constitute best safeguard of the liberty in a liberal democracy? Okay. Committed judiciary, centralization of powers, elected government, separation of powers. What is the answer? Which one of the following factors constitute best safeguards for the liberty? In order to provide the protection to the liberty, what is the best possible answer here? Committed judiciary, centralization of powers, elected government, and separation of powers. Yes? Cheppandi, A ani entamandi antunnaru? How many are saying A? Committed judiciary. Okay. B entamandi? Centralization of powers? Nobody. Elected government? Majority of people elected government. Separation of powers? Entamandi separation of powers? Because this is the right answer. What is that? Separation of powers is the right answer. Why separation of powers is? What is separation of powers? You are distributing the power of the state among the three important organs. What are those? Legislature, executive, and judiciary. Legislature requires to make the laws. Executive requires to apply these laws or operate the various systems of the government. And third one is judiciary is supposed to interpret the laws, safeguard the constitution, safeguard the laws. This is what the purpose of judiciary. Now you just understand with that sense. Committed judiciary means, actually according to Indira Gandhi, committed judiciary means the government, the judiciary which supports the cause of the government. So hence, committed judiciary gives multiple opinions, multiple interpretations. Well, to what it is committed, whether is it committed to constitution, whether is it committed to executive, to what it is committed. So there is no clear meaning here. That's why first option is eliminated. As you all believe, centralization is absolutely wrong. Okay, because centralization will definitely develop the dictatorship. So then it has no connection with the liberty. Okay, right, no nexus with the liberty. Elected government, tell me whether every elected government will be a democratic government. Certainly no, because you did not anticipate the internal emergency imposed by the Indira Gandhi. Because in the 1971 election, Indira Gandhi managed to get more than 350 seats on her own. How many seats, sir? 350 seats. The very best example for the popular government, Indira Gandhi government. But still what happened? In 1975, it has imposed the emergency. That too on the ground of internal disturbance. What is that? Internal disturbance. Very, very opaque term, which was later replaced by 44th Constitutional Amendment Act of 1978. With what term? Armed rebellion. Armed rebellion. So hence, elected governments may not be necessarily governments to safeguard the liberty. Then what is the next option? Separation of powers. Why separation of powers? Because one organ will be having the checks and balances over the other organ. If one organ spoils the liberty of the individual or violates the liberty of individuals, definitely the other organ will come at the rescue of the constitution. Because in India, what is supreme? Whether judiciary is supreme, parliament is supreme, or executive is supreme, or whether constitution is supreme. Constitution is supreme. Supremacy of the constitution. What is that? Supremacy of the constitution. In 1973, the Keshananda Bharti case, in Keshananda Bharti case, Supreme Court proposed a basic structure doctrine. What is that? Basic structure doctrine. It is nothing but the manifestation of supremacy of the constitution. What is that? Supremacy of the constitution. Ardhamoutunda meeku point? Yes, this is how you have to answer the question. Okay, right. Right. So you just look at another important issue. This is a question related to governance. Question related to governance. Most of the instances, governance questions can be answered with your intuition. Answered with your intuition. You don't require to study these statements as it is in the textbooks. Because when you observe the things, you can easily get the inference. What could be the right answer? What could be the wrong answer? Okay, right. Have you seen ASHA workers at the villages? Do you know ASHA workers? Who are ASHA? Accredited social healthcare activists. Accredited social healthcare activists. These are the part of the community healthcare system. What is that? Community mobilization for the health system in the country. Community mobilization. Why we are mobilizing the community? Because the state resources are very scarce. The state is not able to meet the health demands of the people. The state is not able to supply sufficient number of doctors. In this context, you need to mobilize the community for developing the preventive healthcare in the country. What is that? Preventive healthcare in the country. Preventive healthcare means before the disease attacks the person, you are giving the safeguards to the individual. You are creating the awareness. You are ensuring the vaccination. You are ensuring the vaccination. Have you seen ASHA workers? They will be carrying a kit every time. Whenever there is a need, immediately they will be giving the tablets to the people. Got my point? So this is the sense. So look at this statements. Number one, India's public sector healthcare system largely focuses on curative care with limited preventive and promotive and rehabilitation care. Tell me whether the statement is correct or wrong. Is it correct or wrong? నేను చెప్పిన ఎక్స్ప్లెనేషన్ విన్నారు కదా, విన్నారా లేదా? ఆశా వర్కర్స్ పని ఏంటి? ప్రివెన్షన్ ఆర్ క్యూరేషన్? ప్రివెన్షన్, ఐ టోల్డ్ యూ. అర్థమవుతుందా? అంగన్వాడీస్ ఏం చేస్తారు? న్యూట్రిషియస్ మీల్స్ ఇస్తారు ఫర్ బోత్ ప్రెగ్నెంట్ అండ్ చిల్డ్రన్. ఓకే, and they will also be monitoring the vaccination, whether the child is actually receiving the vaccine or not. That is monitored by village level people itself. So hence India is focuses on what is that? What is that? Preventive care, not only curative care. So statement is right or wrong? Wrong, because India focuses both on the curative care and also preventive care. So this is how you have to apply your general understanding of the system. Got my point? Right. Next one, statement number 2. Under India's decentralized approach to healthcare deliveries, the states are primarily responsible for organizing health services. Is it true or false? True. True. It is the statement is true. Why? Because the health services fall under which list? State list. Health falls under state list. Got my point? Whenever you get any doubts whether a subject matter belongs to state list or concurrent list or union list, you need to apply a principle. I told you some of the students it has been covered. Okay, because I don't teach the same content in every class. It varies from class to class. I think some of the students might have listened. What is this principle of? What is that? Subsidiarity. Do you remember what is the principle of subsidiarity? Principle of subsidiarity means it is a principle which says that power must be exercised closest to the people. What is that? Closest to the people. Power must be exercised closest to the people. Why closest to the people? Because people will have access. People will participate in the decision making process. The state must be giving the maximum power to the individual. Maximum power to the individual. This is the general principle behind any distribution of powers between state and the center. If you try to look at this principle, suppose if he is an individual, if he is not able to perform his work, who will come into the picture? Community. Who will come into the picture? Community. For example, ASHA workers. For example, cooperatives. Got my point? Wherever individual is not able to govern himself, not able to provide services for himself, who will come into the picture? Community. In the absence, if the community is not able to do the function, who will come into the picture? What is that? Local bodies. If the local bodies limit is not sufficient, their capacity is not sufficient to meet such requirement, who will have to come into the picture? State government. Because state government requires to control or regulate such matters which require homogeneity or uniformity across the state. Homogeneity or uniformity across the state. Where the matters required to be treated with diversity, those must be dealt by local bodies. Where it requires uniformity, that is to be dealt by state government. Where such thing requires national level uniformity, that is by union government. That is by union government. Did you understand? So hence, law and order falls under which list? Now tell me. State list. Defense falls under which list? Union list. Education falls under which list? Concurrent list. Why concurrent list? It is also a matter of national importance, but better managed by the states. So which gives a common legislative sphere for both states and the center. Got my point? So this principle you need to keep in the mind. Using this principle, you just go through the general details of the matters mentioned under the union list, state list and the concurrent list. Just have a glance. Then you remember this principle. Most of the provisions will definitely fall under this principle. If you know this principle, you can easily identify what are the subject matters of administration for the state, center, and which are falling under the which list? Concurrent list. Got my point? Yes. Suppose criminal justice system falls under which list? Criminal justice system. That is courts, criminal laws, concurrent list. What is that? Concurrent list. Because it is a matter which requires national level uniformity and execution at the state level. Got my point? Because public order falls under state list. So you need to identify this way. Okay? Right. So first statement is correct and incorrect, and second statement is correct. Okay. What is the right answer? Statement 1 is incorrect. Statement 2 is correct. Okay. Right. This is another important question. You just look at really people never expected this kind of question from UPSC. It is literally a bouncer. Why? Because you just look at in which of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretation of the fundamental rights. Ardhamaitunda question? Did you understand this question? What is that question? In India, which one of the following constitutional amendments was widely believed to be enacted to overcome judicial interpretations of the fundamental rights? Right? Which act? Judicial interpretations of the fundamental rights. A Amendment Act. ఎలా చెప్తారు? In which basis and on what basis you can say this answer? అర్థమవుతుందా? ఎందుకు 42nd Amendment Act? Got my point? Actually, ఫస్ట్ మీరు మైండ్లో మీరు పాలిటీ బుక్ ఓపెన్ చేసినప్పుడు ఫండమెంటల్ రైట్స్ డిపిఎస్పి చదివేటప్పుడు మీరు ఫస్ట్ గుర్తుంచుకోవాల్సిన పాయింట్ ఏంటంటే ఇన్ ద కాన్స్టిట్యూషన్ there are two inconsistent parts mentioned. What are the inconsistent parts with each other? Fundamental rights and what is that? Directive principles. Fundamental rights are negative in nature. DPSP are positive in nature. Ardhamautunda? Suppose if a person is inflicted with both TB and sugar, the TB says you eat more. The sugar says you eat less. What the person has to do? Whether he has to eat more or less. That is the case with Indian Constitution. Because the DPSP says you need to enhance the positive liberty. You need to enhance the positive liberty. You need to make more and more laws so that liberty of the people will be expanded because opportunities can be increasing. Suppose if you try to look at Article 39 Class B of the Constitution. What does it say? The material resources must be placed under the common disposal of the people. You need to distribute the wealth of the society. 39 Class C, deconcentrate the wealth in the society. Deconcentrate the wealth in the society. Create employment, Article 41, right to work. 38 Class 2, reduce the inequalities in status and opportunities. 38 Class 2. Got my point? Because primarily Indian Constitution is a welfare constitution. What is the meaning of welfare constitution? It is a state which has to ensure the well-being of the people, secure the well-being of the people socially, economically and politically. Got my point? But on the other hand, the fundamental rights, especially with respect to property. Article 31, previously it was talking about, what is that? Right to compensation. Right to compensation. If the state takes away your property, the state has to pay market matched compensation. How much value the property is having in the market, such money has to be provided, has to be paid to the landlord. Tell me, is it possible? Vishnu Ramachandra Reddy, who was a Jamindar from Telangana at that point of time, he was having more than 50,000 acres. Tell me, is it reasonable to safeguard his property right under Article 31 of the Constitution? Is it correct according to your moral framework? Not at all. That's why judiciary was more insisting upon the enforcement of the fundamental rights, irrespective of the land he is having, irrespective of the amount of land he is having. That's why there was a flood of cases which started coming to the Supreme Court. The first of such case was Kameshwar Singh versus State of Bihar. What is that? Kameshwar Singh versus State of Bihar. In the Kameshwar Singh versus State of Bihar, Supreme Court has literally read Article 31. Court changes the suppose you file a petition, court does not get into the pain that is suffering by the people. What does the judiciary is more interested? Facts. What the law says, first of all, I don't look at your emotion. Article 14, what is that? Equality before law. Law does not look at your status. Law actually looks at the fact. What is the fact here? Article 31, which guarantees the compensation. Article 19, class 1, subclass F, which guarantees the management of the property by the individual. Management of the property by individual. Okay, now tell me, if you are implementing Article 39, class B and class C, which says wealth must be distributed in the society, which articles are being infringed here? What is the article? 31 is infringed. 19 class 1 subclass F is infringed, and also Article 14 is also under the violation, because Article 14 says rule of law, equality before law, right? Then it was challenged. Supreme Court held that the land reform acts, land reform laws, for example, abolition of Jamindari system, protection of the rights of the tenants, and land ceiling acts, these are, what is that? Unconstitutional. What is that? Unconstitutional. Because under Article 13 class 2 of the Constitution, invalidation of the post-constitutional laws, invalidation of the post-constitutional laws, if they are against the fundamental rights, Looking at this state of affairs, then the Parliament has decided to bring, what is that? What is that? First Constitutional Amendment Act. What is the first Constitutional Amendment Act? Article 31A and Article 31B were added to the Constitution as an exemptions to which article? Article 31. Article 31 and Article 19 class 1 subclass F. Are you able to follow? Because Supreme Court has invalidated the land reform legislations. Then there is no option in the hands of the legislature except to amend the Constitution to provide exemptions under Article 31 of the Constitution in the form of 31A, 31B. What is 31A? 31A provides the exemption to 5 types of laws. How many laws? 5 types of laws. This includes the power of the state to take up the property under a violation of Article 31, power of the state to manage the property, that is a violation of Article 19 class 1 subclass F. For example, acquisition of estates, extinguishment of the rights of the shareholders of a company, amalgamation of the properties, okay, and taking over the management of a company, okay. Not only that, amalgamation of property and what else? For example, mining, suspending the mining leases. Such kind of 5 laws have been mentioned under Article 31A. Whereas 31B included into the Constitution. What is that? What is that schedule? 9 schedule. What is 9 schedule? మీరు ఎప్పుడైనా గంగా రివర్లో మునిగారా? గోదావరిలో స్నానం చేశారా? ఎందుకు చేస్తారు చెప్పండి? మనం ఏమైనా పాపాలు చేస్తే అన్ని కొట్టుకుపోతాయి ఆ ప్రవాహంలో అని చెప్పేసి, పవిత్రమైన నది అని చెప్పేసి, అవునా కాదా? ఇక్కడ కూడా అంతే. ఎనీ లా విచ్ మే బి అఫెక్టింగ్ ఆర్టికల్ 31, 19 class 1 subclass F, such law is included under schedule 9 that cannot be challenged in the judiciary. It means you are effectively providing immunity to the land reform legislations by the provision of 31A and 31B. But you may also ask me the question, sir, 42nd Constitutional Amendment Act is as a consequence of Keshanada Bharti judgment. Okay? And these are the other judgments. This is a correctional judgment. 44th Constitutional Amendment Act is nothing but correctional judgment to correct the, what is that, asymmetric power that is vested with the executive. Okay? To correct the arbitrary action of the executive, this 44th Amendment Act was actually brought. That 86th Constitutional Amendment Act is related to what? including Article 21A to the Article 21 of the Constitution. Article 21A talks about what? Right to education. So now the contest is between first Constitution Amendment Act and the 42nd Constitution Amendment Act. Right? Tell me, which amendment is primarily a response to the interpretation of the fundamental rights, first or 42nd? Which question came first? First Constitution Amendment Act, not 42nd, because 42nd Constitution Amendment Act is a very, very later part of the parliamentary legislations. The primary response from the parliament in the form of first Constitution Amendment Act in response to Kameshwar Singh versus State of Bihar. Okay, which judgment of the Supreme Court has primarily interpreted the fundamental rights, whether Keshananda Bharti case or Kameshwar Singh Prasad case? Kameshwar Singh case. So that's why the answer is, what is that? First Constitution Amendment Act. You just understand how much work you need to do for the sake of examination. This examination is not for the sake of testing our luck. If you thoroughly prepare for the examination, if you thoroughly attend the classes, thoroughly understand the essence of the subject, thoroughly interact with the mentors, you will get this essence. Got my point? So daily you need to go through the previous year's question papers just to test yourself. Whether my thinking is aligned with the examination or not. That thing will be addressed by the previous year's questions. Got my point? Right. So this is a question related to Finance Commission, recommendations regarding the devolution of finances between center to states. Do you know, under Article 275 of the Constitution, okay, the grants shall be transferred from union to the states on the recommendation of the Finance Commission. Article 280 talks about the constitution of the Finance Commission by the President of India. Finance Commission does two important things. One is vertical transfer and horizontal transfer. What is a vertical transfer? From center to the states. From center to the states. And horizontal transfer means if the resources are distributed among the states, that is called as horizontal transfer. Suppose if I offer you chocolates from myself to you, that is what? Vertical transfer. And which person has to get how many chocolates? That is what? Horizontal transfer. But in India, states are not having equal status. They are endowed with a varied amount of resources. Not every state is getting equal amount of resources, or every state is having equal problems. That's why 15th Finance Commission has provided, the Finance Commissions will be providing various bases for the provision of resources. So in that context, the 15th Finance Commission has provided for, what are those? One is income distance. Second one is area. On the basis of area, 15% share is dependent upon area. Income distance will be having the weight of 45%. Okay. Similarly, population of 2011, that is having 15%. Demographic performance, that is having 12.5%. What is demographic performance? Actually, if you maintain this population figure of 1971, okay, that does not reflect the present reality. That does not reflect the present reality. Because 1971 population is different and present day's population is different. And in which states you can see the explosion of the population? Northern Indian states compared to the southern Indian states. How can you say that? Because in the northern states, the total fertility rate, TFR, is more than 2.5 to 3. But in southern states, it is less than 2. That is averagely 1.8. So it means population growth rate is very much lesser in the southern states, more in the northern states. If you take the 1971 base, who will be the beneficiaries? Southern Indian states or northern Indian states? Southern Indian states. At that point of time, population is averagely increasing with the same pace in the southern India also. By the 2011, the population in North India has increased and South India has decreased. So who are the losers here? Southern states. To mitigate the loss suffered by the southern Indian states, what was the factor taken? Demographic performance of 12.5. This is very much important. Okay, right. So this is very much peculiar to the 15th Finance Commission. ఎందుకు ఇదంతా చెప్తున్నానంటే questions are repeatedly asked. They are being repeated. You have seen same question has been interpreted in the multiple times. That's why you need to work on the previous year's questions very intensely. You just go with reverse engineering. You will just go with the reverse engineering. You just find a question and try to think on the question. You open the topic and study. That in that manner you have to study, because I will be giving some important topics for the prelims, sir. Please, you need to take down them. Okay, right. Next, are you bored? Is it okay? Okay. Election Commission of India. What is that? Election Commission of India. Okay. Right. Tell me, first question I am asking you. Election Commission of India is the unitary feature or federal feature of the Constitution? Did you understand my question? Whether is it unitary or federal? Unitary feature. Why unitary feature? Why? Because election commission members are appointed by the union, removed by the union. They will be conducting the elections for the states, that is state legislatures, president, parliament, Rajya Sabha members, Lok Sabha members, legislative council members, legislative assembly, and they are discharging the duties for the states also, but without having without being controlled by the states. That's why it is called as unitary feature. Number one. Number two, election commission of India is a 5-member body. Have you studied election commission in Lakshmikant? Genuinely, I am asking. Did you study? Yes or no? Yes. But tell me answer, what is the strength of Election Commission of India? Okay, this is the problem. See, you need to how do you make the notes? Do you have any idea? How do you make the notes? Generally, you need to go through the topic at least three times. When you study 3 times, the general concepts of the topic will be entirely imbibed into your mind. For example, Election Commission conducts elections for what? You don't require to write in the notes, because it conducts elections, because you have repeatedly studied and you have attended the classes. Naturally, you will remember this is the body which conducts elections for both central government and state government. This is the point, need not be written in the notes. But what need to be written in the notes, the point that what is the strength of Election Commission? What is the strength of Election Commission? That is not specified in the Constitution. Strength of Election Commission is not specified in the Constitution. It is expanded, or the strength is decreased according to the discretion of the President. This point needs to be written in the notes. Got my point? Service condition of the Election Commission members is not written in the Constitution. This point is to be written in the notes. Educational qualifications are not given in the Constitution. This is to be written. Got my point? Whether the Election Commission members, once they retire, can they be employed under any government office is not given in the Constitution. This should be written. This should be written. Okay. And how long they will be holding the office? 65 plus 6. Either 6 years or 65 years, whichever is earlier. This is also not given in the Constitution. But of course, this is decided by the President. Okay. And not only that, the removal of the election commissioner is different. Chief election commissioner is different. The chief election commissioner will be enjoying the parity on par with the Supreme Court judge. How the Supreme Court judge is removed? How the Supreme Court judge is removed? Tell me. By the resolution addressed by the Parliament. Resolution addressed by the Parliament to the President. And the President has to remove. So primarily, if I ask you, who removes the election commissioner or chief election commissioner or Supreme Court judge? It is the President of India. But after the address made by the Parliament. And the chief election commissioner removal is driven by which act? Judges Inquiry Act of 1967. What is that? Judges Inquiry Act of 1967. And the resolution must be passed with what majority? Simple majority or special majority? Special majority. What is special majority? 2/3 of the members present and voting. That must be equal to at least half of the total strength of the house. That is called as special majority. Got my point? So that's why every concept is very much interconnected. Okay, right. Next one. Union Ministry of Home Affairs decides the election schedule. Is it true or false? False. Because Union Ministry has no duty performed with respect to elections except the mobilization of the police forces according to the recommendations of the Election Commission. Who will notify elections? Notification is given by the President. Schedule is done by the Election Commission. Usually the scheduling of the election is announced in the public meeting, in a media meeting, in a media conference by the Election Commission. Okay, right. Election Commission resolves the disputes relating to splits and the mergers of the recognized political parties. Is it true or false? Yes, true. Because we have to discuss a special judgment here. Okay, please be ready. Right? Election Commission pani entante, it is having the quasi-judicial function. What is that? Quasi-judicial function. What is a quasi-judicial function? Basically, if I ask you, Election Commission is a judicial body or non-judicial body? Non-judicial body. If such non-judicial body exercises the judicial function, such body is called as quasi-judicial authority. Simply, what is quasi-judicial authority? If any non-judicial authority is discharging the judicial functions, that is called as quasi-judicial function. Speaker, with respect to the disqualification of the members under Anti-Defection Act, he also acts as the quasi-judicial body, because being a non-judicial body, he is discharging the judicial functions of deciding the disqualification. He is also quasi-judicial body, right? So that's why the Election Commission plays very, very important role with respect to giving the resolving the disputes with respect to the split of the recognized political parties. Recognized political parties means the political parties are recognized as national parties and state parties based on the vote share they have obtained in the election. You just go through the vote share. That is very much factual information that is not required. So based on the vote share they obtained, they will be recognized as national party and state parties. Okay, right. Then recently, if you try to look at the case of the Shiva Sena party. What is that? Shiva Sena party. In Shiva Sena party, there was a split between Uddhav Thackeray and Eknath Shinde. Both factions have been created. Both factions have been created within the Shiva Sena. Every faction is claiming the party. Na the original party and na the original party. My group is having legitimacy means another group is also claiming the same thing. Okay. Now who has to settle that dispute? Election Commission. Ardhamaitunda? Right. Then how the Election Commission decides such dispute? How the Election Commission decides such dispute? Okay, actually there was order called Election Symbols Order of 1968. What is that? Election Symbols Order of 1968. This order has a 15th paragraph. Which paragraph? 15th paragraph, which empowers the Election Commission to resolve the disputes between the recognized political parties. Recognized political parties. Right? If the Election Commission has to resolve such disputes, the Election Commission follows three-pronged approach. Three parameters are identified by the Election Commission. Three parameters are identified by the Election Commission. First parameter is whether the group which has split from the political party, whether is it following the aims and objectives of the political party or not. What is that? Aims and objectives. Every political party will be having its own internal constitution. Internal constitution. Prati political party ko constitution untundi. Their own framework of rules and regulations. Whether such split group is following the rules and regulations or objectives of such political party or not, that is a primary test. That is a primary test. And second test is test of party constitution. Test of party constitution. So, and another important thing means whether the party members are following the constitution or not of that political party. అంటే ఒకటేమో ఎయిమ్స్ అండ్ ఆబ్జెక్టివ్స్ ఫాలో అవుతున్నారా లేదా అనేది ఒకటి, రెండవది పార్టీ కాన్స్టిట్యూషన్ ని ఫాలో అవుతున్నారా లేదా అని రెండవది, అండ్ థర్డ్ వన్ ఈస్ టెస్ట్ ఆఫ్ మెజారిటీ. వాట్ ఈస్ దట్? టెస్ట్ ఆఫ్ మెజారిటీ. విచ్ పార్టీ ఈస్ హ్యావింగ్ అ మెజారిటీ? Majority in terms of two types of members. One is legislative members and party members. In party also there will be office bearers. Office bearers means who hold the offices in the political party. For example, if you take BRS party, who is the working president of BRS? KTR. That is what office. He is called office bearer. There will be a general secretary. There will be a secretary. There will be a district president. This is what organizational offices. Okay. And the members will also be having legislative positions. MLAs, MPs. From the same political party, there will be office bearers and also legislative members. And the Election Commission has to identify the majority both in terms of organization and also legislature. On account of these three factors, the Election Commission has to resolve what is that? The split or mergers of the recognized political parties. Since Eknath Shinde faction has more number of legislators along with it, the Election Commission has decided Shiva Sena belongs to Eknath Shinde. And Shiva Sena's symbol also belongs to Eknath Shinde. In case, if the Election Commission is not able to settle the dispute, and meanwhile elections come in the meanwhile, definitely what will happen? The symbol of the political party will be frozen and other symbols will be given to respective factions, and original symbol will be given to such party after having the adjudication. This is how election commission resolves the dispute. మన ఎగ్జామినేషన్ ఏం అడుగుతారు తెలుసా ఈసారి? ఇదే పాయింట్ ని తిప్పి మళ్ళీ అడుగుతాడు. This point can be asked in the examination. Along with this point, another point can be added. What is that point? Election commission does not resolve the disputes regarding the split in the unrecognized political parties. Unrecognized political parties. Is it true or false? అర్థమవుతుందా? Election commission resolves the disputes among the recognized political parties. This is well settled fact because you have gone through the previous questions, you have said it right. Okay? But what is the question now? Whether is it resolving the disputes regarding the unrecognized political parties? No. Election commission does not resolve such disputes. Rather, election commission will advise such parties to approach the court. Approach the court. Got my point? So this kind of twist will be given in the examination. Got my point? And Supreme Court has ratified this approach of the election commission, in which case Sadiq Ali judgment. What is the judgment? Sadiq Ali judgment of 1971. What is that? Sadiq Ali judgment of 1971 had ratified this three-pronged approach of election commission regarding the parameters of selection. What is that? Whether the split group was deviated from aims and objectives of the political party, and whether the split group is following the constitution of the political party, and third one is what is the test of majority, whether such party is having more members in its support or not, both in terms of organization, both in terms of legislative strength. Got my point? Okay, so this is 1968 order. So this order, the Sadiq Ali case, and also this order explains the powers of the election commission. Got my point? Right. So can you take some questions? So there are many things to be discussed. Of course, I don't know whether we are having time or not, but please take some topics of frequently asked in the examination. Certain topics are frequently asked in the examination. Please don't miss these topics. But don't say, sir, you have given all the topics of polity and you are asking us to study. Please don't think that way. Please write the topics. Schedule areas. First one is schedule areas. Okay, see, look at this schedule areas. This is a one question. Number 2, this is another question, 2022. Number 3, okay, 2023, another question. Okay, number 4, 2013, another question. Look at this frequently asked question. So anyway, any form of question, any topic that is connected to schedule areas, you need to be studying. Okay, right on. First one, schedule areas. Second one, functions of the state government and governors. Functions of the state government and the discretionary functions of the governor. Discretionary functions of the governor. Got my point? Next, constitution amendments. Constitution amendments. Okay, statutory and constitutional bodies. Statutory and constitutional bodies. In 2013, 2023, question was asked: which of the following is a statutory body? Which of the following is a statutory body? Such question was also asked in 2022. Which of the following is a statutory body? So every time you will get a question. Okay. It means how do you approach this question? You need to go through the current affairs. In the current affairs, one or the other statutory body names will be mentioned. Got my point? You need to specially record such observation in the notes. Whenever any statutory body in the Hindu is mentioned, you need to take them, which you don't know. Got my point? So with the year of enactment, you need to write some brief notes. Okay, right. Next, the difference between finance bill, money bill, and constitution amendment bill. This is also being asked very frequently. Difference between finance bill, money bill, and constitution amendment bill. I can explain all these things, but because of the paucity of time, I'm not able to do this. Okay, right? Because in my class, I have explained all these concepts briefly. Do you remember? Yes or no? Gurtunda leda miku? Okay, right. Next, powers of the Supreme Court. Powers of the Supreme Court. powers of the Supreme Court, especially with respect to Article 142. Write down Article 142, Article 129, Article 136, Article 131, 132. ఇవి చాలా చాలా ఇంపార్టెంట్ ఆర్టికల్స్. ఓకే, వాట్ ఈస్ Article 131? Original jurisdiction. What is Article 132? Supreme Court is the highest court of interpretation. What is Article 142? Supreme Court has the power to grant the complete justice and also power to take action in the case of contempt of the court according to the law enacted by the Parliament. What is the law enacted by the Parliament in the case of contempt of the court? Contempt of the Court Act of 1971. Okay, so this power has to be exercised according to Article 129 of the Constitution. What is Article 129? The power of court of record. What is that? Court of record. Okay, what is the court of record means? The judgments of the Supreme Court must be binding precedents, binding legal precedents over the other courts in the country. Got my point? This one for actually Article 121. See, chala interesting question. Article 129 reflects unitary feature or federal feature. చూడండి, ఇది జనరల్గా మీరు ఏ క్వశ్చన్ పేపర్లో చూడరు. ఓకే, నేను అడుగుతున్నా చెప్పండి. Article 129 reflects unitary feature of the Constitution or federal feature of the Constitution? Yes, unitary. Why it is unitary? Because the judgments of the Supreme Court are binding on every level, state level and the district level. So hence it does not recognize the special powers of the states and the center. So hence it is a unitary feature. అంత డైనమిక్గా మీరు ఆలోచిస్తే ఈజీగా మీరు ఆన్సర్ చేస్తారు. అర్థమవుతుందా? రైట్, నెక్స్ట్. ఇది చాలా ఫ్రీక్వెంట్ అడుగుతున్నారు, ఇది కంపల్సరీ రాయండి. సోషల్ క్యాపిటల్ ఆర్ ఇవన్నీ విమెన్ ఇష్యూస్ అన్ని. సోషల్ క్యాపిటల్, మెటర్నిటీ, వీటిపైన గవర్నమెంట్ స్కీమ్స్ అని చదువుకోండి. మెటర్నిటీ, న్యూట్రిషన్, శానిటేషన్, శానిటేషన్ అండ్ హెల్త్. ఈ పాలసీస్ మీరు ఏ పాలసీ చదువుతారో కానీ దీస్ ఏరియాస్ మస్ట్ బి కవర్డ్ ఫర్ యువర్ ప్రిపరేషన్. మిగతా అన్ని చదవండి కానీ ఇవి మ్యాండేటరీగా చదవండి. ఓకే, రైట్, నెక్స్ట్. ఎమర్జెన్సీ ప్రొవిజన్స్, యాంటీ డిఫెక్షన్ యాక్ట్, ఫండమెంటల్ రైట్స్, preamble. Next, committees on center state relations, okay. Next, major features of 42nd and 44th Constitution Amendment Acts, major features of 44th and 42nd Constitution Amendment Acts, because these are very important. Have you studied emergency provisions? Yes or no? I would like to give you some important amendments. Okay, very briefly. I don't want to get into the details. If I ask you, with respect to any provision of the Constitution, any advice is given by the Council of Ministers is binding or not on the President. In which matter the advice given is binding on the President, constitutionally speaking. I'm not talking about any judicial interpretation, because judiciary in two cases. One is Ram Javai versus state of Punjab and Shamsher Singh versus state of Punjab. Okay, in these two cases Supreme Court held that the governor and president are required to abide by the advice of the, what is that, Prime Minister and Council of Ministers at the union level, Chief Minister and Council of Ministers at the state level. This is what judicial interpretation. This is what judiciary has laid down the law. Okay, but apart from this, there is an amendment which made the President of India to abide by the advice of the Prime Minister and Council of Ministers. That is none other than Constitution Amendment. What is that? Constitution Amendment. 24th Constitution Amendment Act. Which one? 24th Constitution Amendment Act made it compulsory on President to give the assent to the Constitution Amendment Bill. Any Constitution Amendment Bill is passed by the Lok Sabha, Rajya Sabha, which is presented for the presidential assent. It is binding on part of the President to give the assent mandatorily. This has been given by 24th Amendment Act of 1971. అర్థమవుతుందా? ఇలాంటి చాలా ఇంపార్టెంట్, ఇలాంటి పాయింట్స్ అన్ని మీరు రాసుకోవాలి నోట్స్లో. అర్థమవుతుందా? ఎస్. నేను అందుకే అంట notes cannot be common to everybody. Your notes might be different from that of your friend notes. You can't borrow the notes of others. Why? Their understanding is different, their memory is different, our memory is different. Got my point? Yes. Next. Articles, especially fundamental rights. Articles need to be remembered. All the fundamental rights you need to have it on the tips. If I ask you any fundamental right, you immediately answer it. Got my point? Yes. See, another important thing. Please study articles from the original constitution, not from the Lakshmikant. Because Lakshmikant, you don't know whether it is original or interpreted. You don't know that. So original articles can be seen in the apps. That is, constitution apps are there, right? So you go through that. You, in your pastime, just go through all the articles in the fundamental rights and DPSP. Okay? Right. Next. Recent Supreme Court judgments. Next. Recent Supreme Court judgments. Recent Supreme Court judgments. Recent Supreme Court judgments. Next point. The committees on electoral reforms. The committees on electoral reforms. The committees on electoral reforms. Okay? Electoral reforms. Because there was a question whether a legislator can contest from 3 constituencies. Yes or no? No, he can contest only from 2 constituencies. Because amendment was brought in 1995, limiting the number of constituencies can be contested only 2. Before that, no limit was there. That's why one of the persons, he was the deputy prime minister. What is his name? I am not able to recollect his name. He has contested in 1991 elections from 3 constituencies. From how many constituencies? 3 constituencies. That was asked in the examination. So that's why electoral reforms committees need to be studied. So recent judgments means very recently, in a case involving Rajasthan governor, Supreme Court has given a verdict. What is the veto power of the governor? What is the veto power of the governor? Okay, write down this case, please. In case of Rajasthan governor, in the case of Rajasthan governor, the governor cannot be having any liberty. Governor cannot be having any liberty to keep the bill pending indefinitely. To keep the bill pending indefinitely without any action. ఇప్పుడు ఈ కాంటెక్స్ట్ లో ఎగ్జామినేషన్ ఏమడుగుతారు తెలుసా? whether governor is having veto power or not. So what you have to understand, according to the Supreme Court judgment, whether pocket veto power is there? No. What is pocket veto? Pocket veto means what? If he holds the bill indefinitely without clearing the bill is called as pocket veto. So according to the Supreme Court judgment, governor shall not be having the pocket veto. So this is how the questions can be framed. So that's why questions will be framed out of the judicial interpretations. Okay? Right. Next. Okay? Right. Next. Regulatory bodies. Basics of regulatory bodies. Right? What are regulatory bodies? Do you have any idea? Regulatory bodies means what? Okay, చెప్పండి. Regulatory bodies మీకు అందరికీ అయిపోయింది కదా పాలిటీ? Yes, done. Then tell me what is regulatory body? ఫస్ట్ పాయింట్ చెప్పండి. రెగ్యులేటరీ బాడీకి ఉన్న ఫస్ట్ ఇంపార్టెంట్ పాయింట్ ఏముంటుంది? ఫస్ట్ ఫీచర్ ఏముంటుంది చెప్పండి. Yes, please answer. Regulatory bodies will always be statutory bodies. Why the question of regulation is coming in the context of liberalization, privatization and globalization? Why in the context of LPG? Because state is withdrawing. When space is left for private sector, but this private sector cannot go against the public interest. How to keep the public interest? By having the regulatory bodies. These regulatory bodies are nothing but creations of the legislations. For example, RBI, for example, TRAI, for example, CCI, Competition Commission of India, SEBI, IRDA, Insurance Regulatory and Development Authority. these will be keeping the level playing field among the private sector and between private sector and the public sector. Got my point? So you need to please go through as many as regulatory bodies possible, because questions can be framed, especially regarding SEBI. In the context of Adani shares matters, SEBI related questions can be asked. And that's why precisely please go through the regulatory bodies. Okay, right, next. Basic definitions involving constitutional terminology. Basic definitions involving constitutional terminology, such as liberty, privacy, etc. Okay, ఇవి ఎప్పుడు రెగ్యులర్గా వస్తున్నాయి ఎగ్జామినేషన్లో? సేమ్ థింగ్స్ ఆర్ బీయింగ్ రిపీటెడ్? ఎస్ ఆర్ నో? లిబర్టీ, ప్రైవసీ, ఎట్సెట్రా. బట్ చూడండి ఇంకొకటి, పుట్టస్వామి వర్సెస్ యూనియన్ ఆఫ్ ఇండియా కేసులో సుప్రీం కోర్ట్ has given a formula to identify whether the law is correct or wrong. Okay, how to identify the right law, how to identify the wrong law, when the state intervention is permissible, when the state intervention is not permissible. Okay, right. First, try down in Puttaswamy judgment. In Puttaswamy judgment, the Supreme Court had provided 3 tests. Supreme Court has provided 3 tests. First one, legality. What is that? Legality, whether the law is legal or illegal. Legality means in the context of the constitution, is it right or wrong? Okay. Number 2, okay, need or necessity. Need or necessity of such law. Need or necessity of such law. అంటే ఊరికే నాకు నచ్చినట్టు నేను లాస్ తీసుకొస్తానంటే కుదరదు. Whether you have the need or not. Example, the Uniform Civil Code of Uttarakhand says the living relationships need to be mandatorily registered. Mandatorily registered. Tell me whether such law will be sustained by the judiciary. You just imagine, according to the Puttaswamy judgment, right to privacy. What is privacy? Privacy means ability to safeguard the intimate relationships without the intervention of the state. Without the intervention of the state, I have the liberty to choose my own living partner. Who are you to decide? Got my point? Unless and until I breach any particular law of the land, such registration is completely against the right to privacy. So hence, on that basis, need is important. Necessity of law. Legality, necessity. Next, third one is proportionality. What is that? Proportionality. Proportionality means there must be a match between objectives and purpose. Objectives and purpose. The objective of the law and the purpose to be met. The purpose to be met. What is the objective of the law? What is the aim of the law? Whether with this law are you able to really get the proper result or not? Is there any nexus between means and ends? Nexus between means and ends. That is, these are the 3 tests have been devised by the Supreme Court in the Puttaswamy judgment. So questions can be framed not directly giving 3 points, but they may be internalizing these points in the form of a question. అర్థమవుతుంది? ఎంత జాగ్రత్తగా చదవాలో అర్థమవుతుంది ఎగ్జామ్కి. So you need to go through this much precisely, okay, for the examination. Okay, next, parliamentary committees. Next, parliamentary committees. Special focus on ethics committee. Special focus on ethics committee, because Moina Mitra has been disqualified on the recommendation of this committee. You need to go through the composition of the committee, year of establishment, formation, and who was the first chairperson. These facts must also be properly studied. Okay, right. అయితే మీరు since the 2013 to the latest examination, one trend is very much visible. What is the trend? You know, previously indices were asked. Press freedom index, human development index, and related polity related indices used to be asked very frequently. Now such kind of questions have phenomenally decreased. But still we don't know, because UPSC examination is completely unpredictable. Who knows? That can be asked again. That's why write down indices and reports. Indices and reports. Okay, next, UCC, Uniform Civil Code. Uniform Civil Code. NALSA. Actually, ఇంకొక 1 hour ఇస్తే నేను కంప్లీట్గా చెప్పేవాడిని, బట్ ఐ డోంట్ నో. లెట్ us wrap up the session. మళ్ళీ ఇంకెప్పుడైనా టైం ఉంటే కలుద్దాం. ఓకే, ఎందుకంటే చాలా ఉన్నాయి పాయింట్స్ యాక్చువల్లీ. ఓకే, నల్సా పైన చాలా క్వశ్చన్స్ అడుగుతున్నారు. ఫ్రీ లీగల్ ఎయిడ్ పైన రొటీన్గా అడుగుతున్నారు క్వశ్చన్స్. నేషనల్ లీగల్ సర్వీసెస్ అథారిటీ విచ్ హెస్ బీన్ క్రియేటెడ్ అండర్ విచ్ ఆర్టికల్? ఏ ఆర్టికల్ కింద? 39A. 39A. What is 39A? The duty of the state to create the equal opportunities for justice. Both access and opportunities must be created by the state. అర్థమవుతుందా? ఇప్పుడు ఒక సింపుల్ పాయింట్ చెప్తా. సో ఐ విల్ బి ర్యాపింగ్ అప్ ఎనీవే. ఆర్టికల్ 14 ఏం చెప్తుంది? ఈక్వాలిటీ బిఫోర్ లా. ఓకే, అంటే కోర్టుకి వెళ్ళారు ఎప్పుడైనా మీరు? తప్పేం కాదు, వెళ్తే నేరస్తుడే వెళ్ళకండి అంతే. ఓకే, ఇన్ ద కోర్ట్ the lady justice is blindfolded. She bears a sword in one hand. With another hand, she also has a balance. అంటే ఏంటి? నా ముందుకు రిచ్ పర్సన్ వచ్చినా, పూర్ పర్సన్ వచ్చినా, డిజేబుల్డ్ వచ్చినా, ఏబుల్ బాడీడ్ వచ్చినా, ఐ విల్ బి గివింగ్ ద సేమ్ జస్టిస్. ఇప్పుడు కుమారి ఆంటీ దగ్గరికి వెళ్తే మటన్ చికెన్ క్వాలిటీలో వేరియేషన్ ఉంటుందా? మీ స్టేటస్ని బట్టి ఉండదు. యూ విల్ బి సర్వ్డ్ విత్ ఈక్వల్ క్వాంటిటీ ఆఫ్ మటన్ అండ్ చికెన్. ఓకే, రైట్. నాకు ఎక్కువ ఆకలి అవుతుందన్న అంతే క్వాంటిటీ, తక్కువ ఆకలి అవుతుందన్న అంతే క్వాంటిటీ, రైట్? మరి ఇంత ఈక్వాలిటీ మెయింటైన్ చేసేటువంటి సిస్టంలో బట్ పీపుల్ ఆర్ హ్యావింగ్ ద వేరీడ్ యాక్సెస్ టు ద జ్యుడిషియరీ. యూ కాంట్ హైర్ అన్ అడ్వకేట్ హూ కెన్ చార్జ్ యూ 1 crore, బట్ చంద్రబాబు నాయుడు కెన్ హైర్. Got my point? That's why you need to give reasonable opportunities to access. That is guaranteed by Article 39A, where the state has to implement the schemes and mechanisms to give free legal aid and equal opportunities for the justice. So that's why NALSA Act was enacted, where alternative dispute resolutions will be promoted. Number 1. Number 2, free legal aid will be facilitated. Free legal aid means arranging an advocate, getting you a copy of judgment at the free of cost, free drafting of your case, and paying the court fees by the government itself. In this way, free legal aid is given. So these details must be properly studied. Okay, in this way you have to prepare for the examination. Got my point? Did you get the clarity? Whether our purpose of class is completely met? Yes, thank you so much.